Hi, good afternoon. This is Senate Judiciary for our afternoon session to kind of have committee discussion about what we heard this morning from various witnesses. And also before we leave, hopefully schedule another meeting to hear from DCF with their ideas and put together a bill that can be a committee bill in January. I'm still eating. So, Eric, I'm going to turn it over to you.
Thank you, Senator Sears, and good afternoon, everybody. This is Eric Fitzpatrick with the Office of Legislative Counsel. Just wanted to take a moment and thank Senator Sears for giving us this moment to introduce the committee to our new Judiciary Attorney, Ben Nabogroski. Today is his very first day with us in the office. He's been on board, I guess I'd say, since about 9 o'clock this morning. So it's still pretty fresh, but we're feeling very fortunate, very lucky to have Ben. He's come to our office from the Office of Professional Regulation over at the Secretary of State's office. Went to law school in Albany at Albany Law School. He's got prior experience in the New York State General Assembly when he was in law school himself. So we feel very fortunate. We went through an extensive and, as is always the case, lengthy application/interview process, and we're lucky to come up with Ben. And as you know, Bryn has done an amazing job for us all these years. She's moved on to become executive director of the Cannabis Control Board, so we had that slot open. So Ben will hopefully be filling in some of her portfolio as well, picking up some of the law enforcement regulation issues. He's going to be able to listen in today to the juvenile stuff, matters that the committee discusses this afternoon, so that down the road might be able to pick up some of that as well. But with a number of issues he's going to be able to help us out with, and we're all looking forward to that. So please join me. Welcome, Ben, and I'll turn it over to you, Ben, to say hello.
Welcome, Ben.
Well, thank you, Senators. Thank you, Eric. As Eric said, my name is Ben Nabogroski. I came over from OPR. I previously had worked as a litigator before that for a few years. I'm very excited to be working with all of you. And as I kind of telegraphed before, Senator Nick, I think we might have sort of a attenuated connection, so to speak. My former boss at the New York State Minority Counsel's office, Ed Wick, I think oversaw your daughter a couple years after my internship was completed. When I was talking to him about this job, he said, "Oh, make sure you track her down and say hi for me," and everything. So I'm saying hi on his behalf, and I'm excited to be working with all of you.
Wow.
Very nice.
Pleasure. I just to let you know a little bit about us, and I'll start by introducing myself. Sears, I represent Bennington County and the town of Wilmington. I've been on the Judiciary Committee. It will starting my 30th year next January. And I can't say I've enjoyed every minute, but we have been fortunate to have tremendous staff from Legislative Council, and I'm sure you'll be involved in that, and we look forward to working with you. I remember back in the day when I started, Charlie Bristow was the Legislative Counsel to the Judiciary Committee, and was not before computers, but he did have a word processor in his office. And so when we'd make changes to bills, he'd have to run over to his office, make the changes, and come back. And we had this senator you may meet. He's a state attorney now in Essex County, and he's also represents the VSEA in a number of matters. His name was Vincent Aluzzi, and Vince loved his red pen. And so he would look at Charlie's draft, and then he would start marking it up with a red pen. And then we would get to the floor with the bill. Sometimes the red pen wasn't what the committee had approved. So well, we hope we've advanced to some extent that we're moved forward now that we have all the technology. It's a pleasure to meet you. I'll turn it over to our vice chair to introduce himself.
Thank you. Good to meet you, Ben. I'm Phil Baruth. I represent Chittenden County, and this is will be the start of my 4th year on the committee. Look forward to working with you.
Likewise.
And I'll pass it
And
to
Senator Nika, you
Nika.
just met.
So I'm back on the screen here. And Ben, it's very nice to meet you. I just saw my daughter Abigail, who was your predecessor at some point with Ed Wick, who also went to law school. She's working in New York City now. And I'll be very happy to share with her that you're here. And it's great. Thanks. So congratulations on getting here.
Senator Benning is an attorney, a defense attorney in Caledonia County, and so he's not with us right now. He's working on conditions of release for one of his clients. So I'm sure he'll be back. Senator White.
Hi, Ben. Nice to meet you. I'm Jeanette White. I come from Windham County, which is exits 1 through 5 or 6 on the Interstate 91. And I live in Putney. And I think I'm starting my 6th year. I don't remember. It's such a pleasure that I just forget when I started.
Nice to meet you, Senator White.
Want to introduce himself? Nope, no, he's not really back.
There he is.
Oh, there he is.
Sorry about that, Ben. I'm an attorney too, and today just happens to be everything exploding with respect to the court system, and I'm coming and going multitasking. I've been an attorney for about 38, going on 39 years now, and I'm senator from Caledonia District, which is all of Caledonia County and the 6 northeasternmost towns in Orange County. So when Dick referred to the little kerfuffle about Orange being in Orange, Orange still isn't in Orange. It's still now in Caledonia, and they very much would like to get back to Orange County, by the way. So for whatever that's worth, but I'll look forward to seeing you. You're actually part of a great team for the judicial entities in our state legislative council. They're very good people to work with and very intelligent. You've got a lot to live up to as you walk into that scene. So best of luck.
Thank you very much, Senator Benning. Hopefully I can live up to the billing, so to speak.
And we're also fortunate today that many of the witnesses that are online with us are people that we sometimes refer to as the usual suspects when we're trying to set an agenda. But with all due respect to Marshall Paul, who's the juvenile defender, Evan Neenan, who represents the state's attorneys, Jennifer Pullman, who represents the Center for Crime Victim Services, and Jessica Bernard, who represents the Vermont Network Against Domestic Violence and Sexual Assault. They're with us right now, and I'm sure many others will be joining us. And so it really is a good group to work with, even when we have disagreements or they have disagreements about policy or we do. We're usually able to work it out. We've had excellent working relationships with all of them. And Judge Zone is not here today, but he represents the Judiciary, and he just took over that role on the 1st of November. We're also in Judiciary take on corrections policy, which our new corrections commissioner started on November 1st. So anyhow, why don't we kind of get back, and Eric, if you could help us to kind of digest some of the suggestions and how we would put that together, and maybe have committee discussion about things that you absolutely don't want to see changed and things that you're open to that we could put into the bill and then mark it and then discuss it at our final meeting before January.
Yes.
I'm going to
Thank you,
start
Senator.
it off. There's one thing that no, go ahead, Eric, please.
Well, we might have been saying the same thing, Senator Sears, if you were going to ask me to sort of provide a little decision tree or something of that nature. I was probably going to say that the first question would be the pause. You know, it's probably the overarching question that the committee may want to discuss as to whether or not the raise the age initiative which, as we've discussed many times, increases the age at which person can be subject to juvenile proceedings, currently scheduled to go into effect July 1st, 2022. Question is, there's been discussion as to whether or not to pause that July 1st, 2022 implementation date, and if so, for how long? And should it be paused to a date certain, or should it be paused up to the discretion of a particular agency, perhaps within the executive branch? I think those are the related issues to that question. But the overarching question is, do you want to pause, and if so, for how long?
Yeah, I'm not necessarily opposed to a pause, but I do want a date certain. Bill, you wanted to?
Yeah, I was going to say much the same thing. This gets into another issue too, but listening to the administration, the various representatives, it seems like they're sort of hinting at something that they would like to be discretionary in several ways. So first of all, Commissioner Brown today was talking about, as I heard him, not necessarily having crimes that were listed in statute that automatically were eligible, but rather that they would be more case by case with, the agencies having more discretion there. And they said much the same thing about the timeline, that they wanted the heads of agencies to be able to give a thumbs up when they felt conditions were right. And I lean the other way on both questions. I think it's good for us with this particular statutory push to be clear about when it would start and who would qualify, rather than leaving that up to the executive branch to do on a case-by-case, moment-to-moment basis. So I favor a pause for, I think most often mentioned was 1 year. That makes sense to me, and so I agree with you there.
Any other committee member?
So, Alice, I also agree that pause seems necessary indefinitely for a set period of time. Otherwise, it could totally get lost. And if there's still trouble, it would just be put off and put off. I mean, it may well be that when the date comes about, things may not be such that it could be implemented yet, and maybe you'd have to add more time, but it definitely should be a date certain. And I think, I don't think you'd want any, it needs to be very clear as to who can get in and who can't. And then maybe some people won't make it in there, but I think just to leave that loose, there could be all kinds of manipulating going on, and some people not getting in who should, and some who shouldn't. I just think that needs to be clear guidelines also.
I would agree with
So that's all.
Senator White, Senator Benning.
Yeah, I agree with everything that was said, and I feel a little more amenable to a pause because of COVID. I think that's had a huge impact on the ability to provide services, but I think that it could just be drawn out forever, because we will never, ever, ever have enough services for everybody that needs the service. We don't now in any other program or any other venue. So if we waited until we had exactly the number of services and the money for them, we would never do it. So I agree with everything that's been said.
So in the line of everything that's been said,
Joe?
has been said, I agree with everything that everybody else has said and don't need to carry it any further.
Well, let's start with a year's pause, Eric.
Okay.
Yeah.
And see, and then obviously people can discuss it. But it seems like there's unanimity here that we would support a year. Also recognizing that 19-year-olds should still be treated as youthful offenders. So they do have an avenue to stay, to raise the age pause doesn't necessarily leave them out. I wanted to mention one thing that we didn't hear today, but we did hear at one of our earlier meetings, and that was a number of kids and adults, by the way, that are going through diversion. And there may need to be some, there's a huge increase, but that got slowed down by the COVID. And Joe may know more about that than I do because he's practicing it, but so many cases are backlogged right now that there may be a huge push onto diversion at some point. But I don't know where those cases are, and I know, so that's another factor that would come into the pause. Because one of the ideas in the implementation report was an increased usage of diversion for kids 18 and 19 and younger. That are there any of the confidentiality issues that both Jennifer Pullman and Jessica Barnquist, am I pronouncing it right, Jen? Brought up today in their drafts? Is there anything that's really a non-starter? Marshall said he didn't disagree with some of the clarifications. Should we put that in the draft?
Yeah, it was interesting that he
Underway.
didn't see any real changes, just clarifications. So if that really is the case, I'm okay. I didn't look at it carefully enough to know whether they truly are clarifications as opposed to major changes, but I will trust Marshall on that one.
So that would be something else we could add, Eric.
Yep.
And this is just going to be a draft. So, I mean, there's no decision made that, yes, we approve of this or don't approve of this. My biggest concern was there's certain information that is protected by HIPAA. There's certain information that's, protected in a variety of ways. You don't want that information getting out. Treatment information. Also, if you would look back at the law that we passed regarding Eric, this is old, but it was to make parents responsible when there was a lot of damage done in terms of restitution. And I don't know whether that should be updated or not in light of what we're talking about.
Yeah, that does ring a bell. I'll track that down, Senator Sears.
I wonder, after someone turns 18 and they have, as Jessica said, and they can start trying to collect after they turn 18, for how long does that go on? I mean, does that go on indefinitely when they're, say, 35? Can they still pursue that? I'm wondering about that. Oh, Jennifer's there.
Yes, it does. Once it's in effect, we do have that ability to continue to pursue restitution until it is satisfied.
Until it is satisfied. I see.
Yeah.
Okay. Mm-hmm.
But again, we only have civil remedies at our disposal, so there are no collateral consequences whatsoever with respect to any criminal, anything that can be addressed with the criminal system. It's completely civil and enforceable in the same way as any other civil judgment.
I see.
Senator Sears, there was also you were mentioning confidentiality. I think another sort of topic that comes under the category of what was being requested by the center and the network had to do with compensation and restitution. You remember that there was that issue that was raised as well, so that the rights of victims to reimburse for for crime-related expenses would be consistent between the youthful offender and the juvenile proceedings. And there were a couple of places where they suggested language to try and make those provisions consistent. Another topic you may want to think about.
Well, yeah, could you help me? What exactly?
Yeah, for those pieces, you mean?
Yeah.
Yeah. They're really the first three, I think, if anyone happens to have the memo from Jennifer Pullman in the center. First one provides that the victim's right and ability to reimburse for crime-related expenses through the victim's compensation program wouldn't be negatively impacted by the fact that the juvenile's record was sealed. So in other words, there'd be some language added that clarifies that the victim's compensation program can get a redacted copy of the affidavit just for the purpose of verifying the expenses, because claims are submitted to the victim's compensation board to verify how much of a loss of a crime-related loss that the person incurred. So that was the first piece. Similar on there's sort of I think what might be described as a procedural hurdle in some cases, that the fact that there was not a formal restitution order on the books that hadn't been issued in some cases could potentially impact the ability to collect the restitution that had been ordered, the amount of restitution. So again, the proposal would be to add some language that specifies that if the juvenile can't pay the restitution at the time of the disposition, and that part is an existing law, the court shall fix the amount and establish a payment schedule. So in other words, it puts a formal order in place so that any logistical problems that would have come up as a result of not having something formal issued by the court would be avoided, because it would require that if they couldn't actually issue the order at the time of the disposition. And lastly, I think on the same category, there's an existing sentence in statute that says the restitution order, in this case, in a juvenile proceeding, is not confidential. So that there's an exception to the confidentiality requirements generally with respect to restitution orders. And so the proposal is to add another sentence that would say the sealing of the record wouldn't affect the ability of the restitution unit to seek enforcement of the order in the same way that it enforces civil orders generally, civil restitution orders. So the restitution unit has this general authority to enforce restitution orders in court. And this is clarifying that the fact that the juvenile's record is sealed isn't going to mean that the unit can't go to court in the same way they can for other restitution orders. So those are the three things.
What would be? Yeah, I don't have a problem with that, except I wonder what in the real world would happen. A kid who was 16 or 17 or even 18 at the time that the juvenile record was sealed and owed restitution, of getting that restitution when the kid is 21.
That's a good question. I'm not sure the answer to that myself. Like as a practical matter, you mean? What would
I mean, we can say that you still owe the money, but the record's been sealed. It has to have been sealed, except for you still owe that money.
Yeah, I think the order itself wouldn't be confidential, but you're right, the other records would be sealed.
I suppose there's some people who would, I don't know. Jen, do you have any comment on that?
Well, we're working off of an interpretation. This issue was actually drafted quite well in a motion for reconsideration that was in Chittenden County, wherein a young person was seeking to have their records sealed. And unfortunately, at the time, it was denied because the person still owed restitution. And legal aid briefed this issue very well, arguing that we would have still access to, that any sealing would not impact basically restitution judgment order. And as it being in order, we would still be able to enforce that in the way that we do, again, through tax offsets, liens, other civil remedies. And the court accepted that.
So his tax refund could be attached.
Yes,
Okay, that helps.
thank you.
Anyone with questions or concerns about that position? Okay.
So include those for purposes at least of the initial draft.
Yep.
Yep.
Nobody was in it.
There was a bigger issue that came up next that I think that Senator Sears, you had indicated the committee might want to discuss later, which is the ability of victims in juvenile cases to have access to information pre-charge. In other words, before the charge was brought. And I think that was a broader topic that the committee thought you might want to discuss later.
Yeah. Well, I don't have a problem with a victim advocate or support person to accompany them to a pre-dispositional or dispositional hearing. Merits hearing where the victim is ordered or chooses to be present. But I did a little concerned about disclosure of confidential information to others.
So
Senator White.
can I ask a question about that? Is what Eric, I just started thinking about that is if there can be information disclosed before there's actually a charge, that if that information is disclosed before there's a charge and then it goes to family court where it's confidential, it isn't confidential anymore because the information is already, I guess I don't understand that at all, why there would be information available before a charge.
Eric, are you here twice?
Yeah, I'm actually having a bit of a technical problem, and
Okay.
My iPad was what I usually use right here, is losing its charge, and for some reason, it's not maintaining its charge despite the fact that I have it plugged into the wall. So I'm also that's why you see me twice. I'm trying to sign in through my desktop as well.
Okay.
It's actually me.
Okay.
It's not
If
someone
Mike's-
impersonating me.
Okay. Good. Well, I'm just glad there's two Eric Fitzpatricks here.
Yes. For this bill, I may need two of us.
So can somebody explain that to me about the pre-charge information being given out? Why that would be a good thing or what the issue is?
Jennifer, I believe that was your proposal. You comment?
Getting there, thank you. I certainly don't see it as a relevant consideration for non-listed crimes. I think when I'm thinking about this, it's specifically in terms of listed or listed crimes. And the idea is that, I mean, I can certainly understand where the committee is concerned about that, and I don't deny that that is a consideration that we're trying to walk through. And it's more that I'm trying to think about, or we're trying to think about how we balance that when we have a very serious crime. Could be, for example, lewd and lascivious on a child. And when that person the person who's the subject of the investigation could live a block away, let's say, and the victim or the victim's family doesn't have that kind of information. So I think it is a challenging balance. And I do think back to the language that did pass under 107, wherein we were thinking about if it's a safety issue. And I think we could narrow that language even further rather than being involving a threat to the public, but involving a threat to up to the safety of a victim. So again, I appreciate the balance that's at play, and our thought would be is if there's some very narrow way to allow for some basic information to get to victims in these cases. What victims are provided with in criminal cases is a whole host of information from law enforcement around right to compensation, right to other pieces that we don't have there. So I think there is this gap, and we'd appreciate any consideration, and I'd be happy to work with any of the parties more closely, or the stakeholders more closely, about how we could define that in a way that is mindful of the confidentiality that we're trying to maintain as much as possible for young people.
Can I follow up on that? And then Marshall has,
Yep.
I think, an answer. So what kind of information, the person already knows who the offender is. If the victim knows who the offender was, right?
Not
In most cases, no?
not in this particular case that really resonated with me. It was a case out of Franklin County where the victim did not know and was wanting that piece of information to keep that particular person for their safety. And the parties that were involved in the cases didn't think that that was something that could be disclosed or shared until such time as it went forward with a charge. So I do agree that it's not the usual, but to the extent that it has happened, again, thinking through and being welcome to thinking through that. Certainly what I proposed is I'm not, if I were Eric Fitzpatrick, I'd be in a very lucky space. So my language may not get us there, but thinking about language with other parties about how we could maybe think about that.
Marshall.
You're muted,
You're
Marshall.
muted, Marshall.
I got it. Thank you. So I just wanted to make clear that we don't oppose this in principle. I mean, I think the way that I understand what Ms. Pullman is suggesting is that it's basically consistent with what already happens in criminal court in section 5314. And there, the information that's given to the victims of all offenses is very generic. It's about how to contact victim services, what services might be available. And the identifying information is only given out in cases of listed offenses. That's in section 5314B. And we would not object to a similar structure in the juvenile code because frankly, we agree that there are cases where people don't know the identity of the person and they should have that information. We think that it's going to be possible to come up with some way to do that protects confidentiality generally. That was something that was certainly contemplated in S107. And I think, I'm not ready right now to propose exactly how that would be done because I can think of a few different ways to do it. And I want to sort of talk internally about how that could be done. But we certainly don't see a problem with this. And in fact, would support it because it fills in a hole that we have. There's not specificity in the juvenile chapters about what happens for pre-charge information, and that ought to be clarified.
Could we just take what was in S107 and put that in our draft, Eric?
Yeah, for now. And you want I'll just.
Yeah.
If they
And
agree
that
on
would
language
allow,
later.
yeah, and we can, that would allow Jennifer and Marshall and any others to propose changes to that, but at least it's a placeholder. And since we already, probably all of us already voted for that, I guess.
Well, we, are you putting the whole thing in? the
No,
whole?
no, just that,
Oh, okay, just that about public
just that,
safety.
yeah, a public agency may disclose identifying information relating to the initial arrest of a person under 19 years of age in order to protect the health and safety of any person.
Okay,
That's what was in 107, and I'm suggesting that.
Yeah.
Take that out, or put that in as
Yep.
part of the draft. It would actually help the case that that I got involved in Orleans County. Okay. Where are we next, Eric?
The next several
Or Eric
pieces are all,
I see, I've got two Eric Fitzpatricks, so I'm going to refer to Eric Fitzpatrick 1 rather than 2.
that makes sense. Thank you. The next several proposals are related. Senator Sears, are connected to the idea of, and I think you may have been mentioning this earlier, the victim's right to have a victim's advocate there, similar to the way they have in other criminal proceedings. Victim's right to know the conditions of release and conditions of probation in the same way they have similar rights in adult proceedings. So those three are sort of, you might say, again, dealing with the issue of consistency between opportunities to have knowledge and be notified of the proceedings between juvenile proceedings and adult ones.
Yeah, I don't. Anybody with a problem with any of those?
Nope.
So those are okay. The next ones, a couple of them had to do with, in existing statute, as you know, if the information about the court proceeding is confidential and it can't be disclosed, then it's unlawful to disclose it. The statutes in the juvenile statutes in a couple of places specifically say that the victim is informed that it's unlawful to disclose this confidential information concerning the proceedings. So there's, and I think that was also in, it's in both proposals from the center and from the network. Proposal is to strike that language so that it, the specific requirement that that the victim be notified that disclosure is unlawful would be struck. And so I guess that's the first one to talk about.
Senator White.
so I thought that what was lawful to talk about was that you could talk about who the offender was, but you couldn't talk about any of the court proceedings. So why would we take that out? That I don't have the thing in front of me right now again, but the proposal, but why would we take out that it's illegal to talk about the court proceedings? Because it is. Isn't that, I mean, I'm confused there, maybe.
I think you're correct on the distinction, Senator White. You might want to hear from the advocates as to why the proposal is to remove that. But I think you're right about the distinction between what can be discussed and what can't.
Jessica?
Hi. Jessica Barquist from the Vermont Network. So this is where we get into that distinction between what they can talk about publicly and that ability for them to be able to talk to their therapist or their parent or their, close, confident support people. And so that's why we recommended adding in language around being really explicit that it is not illegal to talk about their experiences, but also striking this to kind of get at that balance so that they can talk to their parents and their therapists and those really close support people without fear of that confidentiality. So that might not be the right way to go about it, but that was the intent of what we were looking at there.
Why would people want to talk about the court proceedings, even with their close support group? And my close support group might be my Facebook friends. I mean, I don't know how you draw the line here. You can talk to your mom and dad and your therapist, but you can't talk to your brother and sister and your Facebook friends, even though those are the ones that give you the most support whenever you're dealing with something. I'm really uncomfortable with this.
I would agree with Senator White. I think it's, you can come up with those examples of parents and therapists, but again, I worry about that being a slightly slippery slope. And so I second that.
I thought Marshall had given an example of how a judge interpreted it. That he mentioned how a judge described it. That you certainly could talk to friends. You could talk to just about anybody you wanted to, except about the things that happened in the courtroom.
Well, and that's what this is saying, that you can talk about. By removing that language, it says you can talk about those things.
Well, that's apparently how it's been interpreted already.
Not that you could talk about what goes on in court. I thought
Can you
that was
take over
always.
for a second, Phil?
Oh,
Yep, will do.
Marshall,
I thought that it was always that you could, and I thought that what was being asked was that people could say who the offender was. And as Marshall said, that's probably a First Amendment issue anyway.
right.
But not to talk about what goes on in a confidential court proceedings. And I thought that's what this proposal is asking to get rid of, that you can talk about what goes on in those court proceedings with your close support group, whoever that is. So I might be misinterpreting it.
Marshall, did you want to speak to that?
Or just to clarify, I was speaking specifically just about the narrow issue of what happens in court versus what happened out of court, and that there currently is no prohibition against talking about what happened out of court. There is currently a prohibition about what happened in court.
Right. So Senator White is correct in saying that this seeks to modify that state of affairs.
Yes, and I can say that we certainly don't oppose the idea of having people be able to talk to therapists, counselors. I do have a lot of concerns when it comes to things like family members, because frankly, in these situations, this is where we've had this problem in the past. We actually, honestly, have not had a lot of problems with victims themselves publicizing information about juvenile cases. We've actually had a lot of problems with victims' family members publicizing information about juvenile cases, which they probably got from the victims themselves. And part of the problem is, the court, the legislature has quite a bit of authority to tell people what they can say about what happened in court if they are a party to the proceeding or if they are invited into the proceeding. If they learn about it collaterally, then the legislature can't tell them you can't talk about this thing. That came up in a court case out of Florida where there was some confidential information that a court accidentally released to the news The news had asked for some information. The court sent them the information they had asked for, plus a bunch of unredacted confidential stuff. And the newspaper went ahead and published the stuff that had been mistakenly divulged to them, unlawfully divulged to them. And the federal court stepped in and said, you can't go after the newspaper for that. If somebody, if a newspaper, for example, or an individual gets access to information that they maybe shouldn't have had access to, but they're not party to the court case. So they weren't subject to the court order that said you can't talk about this. You can't restrict them from talking about it. It's again a First Amendment issue. So that's why we have a lot of concerns about expanding it out to family members and the like. If it's therapists, there's no law that says that they can't divulge this information, but they have ethical codes that would prevent them from divulging that information. And so I don't have a problem with that. But I certainly have concerns if it's expanding it to allow people to talk about what happened in court with family members specifically.
Senator Sears, do you want to? Oh, you're muted.
As I said, or be on my tombstone. It's finally completely muted. All right. Yeah, I'm willing to put something in that makes clear you can talk to support persons and so forth. But I'm really concerned about how to make it explicit. I think making it explicitly clarify that victims may talk about their experiences, but it's not lawful to say they were charged as a juvenile or provide any details about the proceedings. That would be important for me to have in there.
Mr. Chair, what about?
Did I miss something?
Well, I was thinking instead of support group, which I think Senator White had a good objection to, what about mental health counselor or professional?
Mm-hmm.
Yeah. No.
How about a 12-year-old that's telling their friends,
Well, they shouldn't. I mean, somebody should tell them that they can't talk about what goes on in court. And
they might want to say how scared they were when they had to testify.
I know.
But, I don't know.
Would that be wrong, saying how scared they were when they had to testify? I don't know.
I think this opens up a lot, but we certainly, I don't know. I really.
I mean, one way to think about it is, and maybe I'm wrong, but it seems like the only way this would ever be prosecuted is if someone has been injured by these disclosures. And so I think we should keep in mind that you're talking about multiple injuries. There's the original crime, or we're at the pre-charge state. So the person hasn't even been charged with that crime. I can only imagine a situation where a charge would be brought if there was some kind of, established injury that had been done to somebody from the disclosure. So I don't think, to speak to Senator Nitka's example, I don't think anybody would bring a charge because a child said they were scared. But if the information was put out in such a way that, impacted or ruined somebody's life, that's when I think it might become an issue. So we're balancing prospective harms to different parties here.
I'm going to actually ask Jennifer and Jessica to come back with a proposal for the committee's concerns about how we can both. I can't imagine being a victim of a crime and then not being able to talk about it.
Yeah.
So I think they should be able to. But it's just, you're saying she couldn't talk about it to her best friend. I don't know if it's the public nature of the conversation. I mean, if you narrowed it to mental health professionals, et cetera, then you would eliminate maybe that person's best friend. She couldn't talk to about it. And I see that victim feeling very isolated.
Well, I think there's a difference between talking about what happened and how you felt and everything, and then talking about what goes on in court. And I think that's where the line is about what goes on in court. And Alice's question about, I was really scared when I had to testify. I'm not sure that that's really talking about what goes on in court.
Well, sorry, go ahead.
But what goes on in court is, and then her mom got up and said this, and then the judge said this, and that I think is unacceptable.
The instance I picture is they're in court. It's a sexual abuse case. They're being asked what happened to them, and the judge interjects a couple of lines also about, where did the person touch you, or other more personal things happened. And the kid goes out and said, the judge asked me who did what to me, and I told him, that kind of thing. I mean, that certainly happens.
Yeah.
And,
I guess
can be worked out perhaps, but.
Yeah, you've heard the concerns, Jennifer and Jessica, and maybe we could
include Marshall
in that discussion. See what we can come up with. Eric?
No, sorry, I was actually gesturing at someone from IT has come over to try and help with my iPad.
Maybe you need a new one.
Yes, thank you, though.
We'd certainly support you getting a new iPad, Eric.
Oh, thank you. I think it's the charger, not the iPad. The iPad's always worked well.
That can be the problem.
Yeah.
I told everybody about it. This is a little offline, but I did get this message from a constituent wanting to know what to do about her father's phone that couldn't get charged, and she's tried everything to get it charged. I wrote back,
I know what the problem is.
I said, I'm a state senator. I don't know.
I know what the problem is. Okay, in your iPhone, especially if you keep it in your pocket, lint builds up in the charging thing, and then it can't connect. And so you get at the supermarket or wherever, you get one of those little cans of compressed air, and you can blow it out, no problem.
Yeah.
I should have told that constituent that.
And she would have thought you were so smart.
She would have. I didn't know that. Phil could have. I should have turned it over to Phil for constituent service.
That's what I need, more constituent services.
Right.
Okay, so anyway, moving right along. I think we have general agreement, Eric, but we would wait for something at our final meeting to be determined. With a little more clarity about what is legal, what wouldn't be legal.
Yeah, and it sounds like keeping in mind the distinction, it's almost like you got a couple of different issues in play simultaneously here, but the one about with reference to the discussion of the victim's experiences and how they feel being distinct from the discussion of the court proceedings, which are two different things. You could add language. I think you were even referring to it, Senator Sears, in the proposal from the network at the very end about, see, there it is. It's gone. Okay. About discussions of the experiences, et cetera, but it is not lawful to say they were charged or otherwise provide details about the proceedings. That might be moved, make more sense considering that the committee is sort of discussing it generally, to the section about rights of victims. the preceding section and just move that statement, something similar, something along those lines that,
Yeah.
that the victim does have the right to discuss their experiences, provided that they are not lawfully able to discuss details about the proceedings themselves, something along those lines. Is that kind of where? at least
That's
part
kind of
what-
where I'm going, but I'm also, as I raised earlier, I'm thinking about the case of Sawyer back in Fairhaven, where how do we limit how many victims there were?
Right.
I can answer that briefly.
Please
Senator.
do.
The definition of victim that's used in the juvenile chapters is the exact same as the definition of victim that's used in the victims' rights section of the of Title 13 of the Criminal Code. And that's limited
Yes,
to
Mike.
the named victim of the offense, like the person who actually suffered the harm that was intended, or in cases where somebody has passed away, then it can include their immediate family. But other than that, that's how narrow it goes. So
That's how narrow the victim is. Okay.
so in the Sawyer case, for example, the original charges were a number of charges of attempted murder. And so for each one of those, there was a named victim. Those were the victims of those charges, and nobody else was. And then as the case progressed, the charges changed, and so the victims changed.
Yep. Okay, that's helpful, Marshall. Thank you. I wonder that pretty well. Are you
Wait, there are
Eric's
three
still having
Erics now.
technical We've got Eric's phone, Eric's 2 and Eric 1.
He did say
I'm
he need
multiplying.
more than one of him to do work on this bill.
That's
Yeah,
right.
Ben, can you help Eric here?
I think we're making progress. That should be one of them just disappeared.
Yes, so did some other people. I think they all disappeared, Eric. Ah, good one, Mike. I like that. Very good, Mike.
I saw that, Mike.
Boy,
All
you
right, well,
just
we've-
got Sears heart, I'll tell you.
We've just
Mike and
switched
I agree
iPads,
on
so
that.
now I'm now
Mike
working
and
on
Mike and I
one with a
agree on
full
that.
charge.
Okay,
Okay. And I don't see Evan here right now.
oh, yeah.
But I'm gonna.
So I think did you want to move to the next topic, Senators?
Yeah, that would be Evan Meenan's.
Oh, sorry. Yeah, go ahead.
Evans had disappeared, though.
Yeah, but I can, I'm going to his example number 1. I mean, that's one of the reasons the need for a secure facility. That's one of the reasons to delay, I think, the establishment of, I've talked with the commissioner. I don't know if it's been, I've had a number of conversations with him about the need for facilities for 18-year-olds. And that's one of the reasons to pause the 19-year-olds. But I'm also wondering about their contract with Beckett. And this is something we can talk to the commissioner about. The contract with Beckett is for only under 18, not 18 or 19-year-olds. So I think that's something that we should require in a report back, say an interim report. If we set a date for a pause, then I think we should require back some report on placements for 18 and 19-year-olds and how they plan. And there's also, I know they're working on something with females and males who may need, for lack of a better term, not necessarily secure housing, but some kind of supervised housing for a period of time.
Dick,
Yep.
just a question about the Beckett project. So in some of the communications that we've got, the people in that community that's one of their ongoing questions, is whether it will remain under 18 or whether it will be in the future expanded to higher age group. Do we have clarity on that from the administration, or is it?
I think they've been pretty clear that Beckett contract wouldn't allow more than over 18.
Okay, and that's a commitment that they couldn't change next year?
Yeah, I mean, anything change, but I mean, that's the current contract, and I don't think Beckett feels they have the experience to work with older youth at this point.
Okay,
You know, but um,
So the report from DCF, Senator Sears, is that what you're thinking?
yeah,
Yeah.
DCF and maybe the Agency of Human Services, or what plans what plans they're putting in place to, like an interim report.
Yep. Got it. That sounds good.
I know they're working with somebody in central Vermont and somebody in Bennington County on some of those, not secure housing, but housing that would transitional. I'm going to use the term transitional housing. The other issue I don't know how to solve. I don't think you can solve it no matter what you do. The idea that kids will, who are 17 and a half or 18 and a half, or when we get to 19 and a half, how do you deal with them other than allowing some form of dual custody between DCF and DOC? If the crime was serious enough to carry adult penalties. What is it now? If the kid committed a Big 12 offense, they're not eligible, correct? Or juvenile?
Well, it has to be filed in the criminal division. But for 14 to 17-year-olds, at least, that can be transferred back to the family division. But for the older ones, no, that would be criminal, unless it got filed filed directly as a youthful offender.
Right, and that might be the only way to keep a hold on somebody who's filed as a youthful offender.
Right, because they do have dual custody of youthful offenders.
Right, so they could continue with that would be another thing. What age appropriate services does DCF have for youthful offenders?
Right.
Well, that's a great word, age appropriate. That's his number 5. Recently, a youth charged with committing 2 sexual assaults against 2 different juvenile girls in 2 different counties sought YO status. It's likely that the recommended rehabilitation programs will last 18 and a half months. The case has not been fully adjudicated, and there's only 18 months left before the youth ages out of jurisdiction. So as a result, the youth may be either denied YO status for lack of available services or age out of YO jurisdiction before completing the recommended program. Didn't Marshall's still here, and is number 2 restrict YO proceedings to 18 to 22-year-olds and change the venue to criminal division rather than family division? Didn't we change that back in 2018 to allow it in the family division? So this would take us back to pre-2018, right?
Yeah, before 2018, it was actually super complicated. It happened in both divisions. There was half of the bifurcated hearing was held in the criminal division. The other half of the bifurcated hearing was held in the family division. Our office certainly supports this happening in the family division, though we agree that there's some problems with ping-ponging cases back and forth. And it's kind of screwy that, if you're charged with something and you want to move down to straight juvenile court as a delinquent, that proceeding to determine whether or not you could move from criminal to juvenile, not criminal to YO, would happen in the criminal division. But if you ask to move from criminal to YO, that happens in the family division. And we certainly could, and I can talk to Evan about this and other stakeholders and try to come up with some language, come up with a scheme that allowed both of those to be heard in the family division, so that at the very least, if there was, the scenarios that Evan and State's Attorney Marthage were talking about, where, a case is going to go YO eventually, but it has to go back and forth before it can go YO, that judges would at least be able to take judicial notice of the testimony from one proceeding and apply it to another proceeding. So I think there's some ways we could work with that.
Yeah, that would be helpful to get that ping pong solved.
I agree.
That's not something we intended, I don't think. What is it?
So should I hold off on that piece? Do you think, is that something that you guys can maybe propose some language on, or, because I had that noted as well as an issue to address.
Yeah, why don't we?
We have a juvenile justice stakeholders group meeting tomorrow, and perhaps we'll be able to report back pretty quickly on what we're going to be able to draft language around and what is going to be more contentious than that.
That sounds fair. If you can get that, if there's something guys can agree on, then that would be helpful to get to Eric. And I don't think anybody has an objection to adding something in to solve that problem. The one thing I'm confused about, the YO require the public safety definition. Has anything been done in the courts, Eric, on that defines what we mean by public safety? Has anybody?
I haven't seen that. Unless Marsh, I haven't seen any Vermont Supreme Court opinions anyway. So possibly a trial court decision, but I haven't heard of that either.
It's been developed a lot in the trial court and really not much at all in the Supreme Court. In fact, I don't think there's a single case where the Supreme Court has taken on sort of what that means or what factors should or should not weigh in it. But it's been addressed in the trial courts quite extensively, though.
Do we need to address that, committee? It's from the 2018 law.
Came up again in one of our previous meetings, came up previously in another meeting. Yes,
Right.
exactly what is it? what do we mean by it? I don't know.
Yeah.
We could certainly codify something that was in one of the trial court decisions if you felt that fleshing it out in statute was helpful or necessary, or I say that without having seen the decision. So I don't know, also,
Right.
you may not agree with the
Well,
substance of it either.
Yeah,
I might be wrong about what I just said. I'm just looking at Westlaw, and it looks like there was in fact a decision where the Supreme Court did look at a judge's decision on public safety. I have not read the decision closely, but just for the committee's information, it's in Re BB, which is 2019 Vermont 86. And I'm just looking at the head notes, which say that it was a case where the Supreme Court upheld a trial court decision, denied youthful offender status, finding that public safety would not be protected. The kid then challenged that at the Supreme Court, and the Supreme Court agreed with the trial court and said, nope, you didn't meet your burden to show that public safety would be protected. But I don't know that, I haven't yet figured out the details of what the reasoning behind the decision was.
well, we could put in a, what do you call them?
Placeholder?
Header, placeholder. Yeah, thank you. A placeholder for what that means.
That was in Re what, Marshall?
In Re BB, B as in boy.
Thank you.
Okay. The other issue that Erica Mathis raised, and it's one that we're all, facing all the time, is she said raise the age is not the issue, but the issue is what services are available county to county. And that goes to the second standard, which is, are the services available? Is the kid amenable to treatment? And I think that has been pretty well taken care of. I'm not sure that's a problem, but DCF can say, well, the services aren't available, which would deny a kid the YO status. And I'm curious if that could be part of the report, is to ensure that services are available statewide. In other words, if the service is available in Chittenden County, but not in Windham County, is that fair to the Windham County person who ends up facing an adult sentence rather than an offender sentence? Just because the
No.
service. No, it's not. I agree. I agree. I mean, I'm not picking on Chittenden. I'm glad you've got services. You know, I've got a mental health center down 4 clinicians. So if that youthful offender needed certain treatment and it's just not available because the designated agency doesn't have it.
Well, that goes back to something that Evan said at one point. He was sort of throwing ideas out, and one of them was that if someone had been denied YO status because of unavailability of services, that they should then be considered, the presumption should be that they shouldn't be eligible later on. And I really, that makes no sense to me, because this system that we have is always underfunded, it always has gaps, and to handicap the people who couldn't get the services permanently because of that just seemed like adding insult to injury.
Are there many cases where YO status is defined because the treatment services are available?
Is that a question for Marshall?
He was
Dick?
Or
shaking his
just a
head.
question for,
I nodded my head. I wasn't sure whether it was directed at me or not, but I'll give a little bit more background. It is a common reason why YO status is denied. I don't actually think that it's wrong. I mean, we all want, in an ideal world, for there to be more services available, more places. But I mean, it's something we see in the adult system as well, is that, we have people who they might be able to get a better sentence if there was better services available, but they're not. And we can always try to make services better. It doesn't always mean that means that, they should get the status or get a better sentence, even absent the availability of the services, because you don't want to set somebody up for failure by, turning them out without services and expecting that they're going to do well on supervision. That's really sort of a recipe for disaster. And frankly, in a lot of cases, our attorneys withdraw youthful offender petitions once it becomes apparent that the services that they need won't be available, because, it's the experience of myself and most of our attorneys that kids who get youthful offender status who are going to do well on supervision, it's very much worth it to go youthful offender. But if you have kids who you think are not going to do well on supervision, it's much better to put them into the adult system and work out a good deal there, rather than face the heavy hammer of an open sentencing if the kid screws up on supervision and gets revoked out of the YO system, because then there's no negotiating, there's no way to limit their exposure, and so they get hit with everything. So frankly, in a lot of cases, it's not that courts are denying YO status due to lack of services. It's that clients, along with their lawyers, are deciding to withdraw their petition and not pursue their petition because they're not likely to be successful without the services.
Senator Sears, can I ask a quick procedural question?
Yep.
As far as the draft goes, did I hear you say earlier you're thinking that the committee bill is the way to go with this?
yeah,
So in that case, that's good. So we don't have to worry about the first week of December deadline, right? You can go for I think committee bills are the end of January or something.
Yep.
January 31st, I think.
yeah, I
Great.
would hope we'd have it ready to go the first week or two.
Yeah.
I think the commissioner brought up the issue of the risk assessment. And we can admit Evan back into the waiting room. And I'm not, it's not, I mean, I don't, both the commissioner and the governor's legal counsel both brought up the issue of assessments. And I'm not sure I want to determine whether or not a kid could be in raise the age just based upon an assessment. But on the other hand, Is that an issue we want to look at? They've had difficulty assessing sex offenders. One of the things for teenagers. So, and that Evan Meenan had suggested in his number 5, develop a list of enumerated offenses that is larger than the Big 12 and listed offenses. Individuals age 14 to 18 who commit an offense aside from enumerated offense will be subject to delinquency petition. Case could be transferred to criminal division if a standard derived from 33 VSA 5204C and D is met. I didn't quite understand all that. Evan, do you want? Are you on right now?
Yes, I am. I just caught the tail end of that question though, but I'd be happy
I'm
to do my
looking at
best
your
to answer
number
it.
5 and understanding you wanted to develop a list of enumerated offenses that's larger than the Big 12 and listed offenses.
Yes, so that goes back to a comment that I was trying to make earlier, which is the department's position is that we should, when we're having conversations like this or in the expungement realm, instead of borrowing the listed offenses as a surrogate for every crime that might be serious in this new context, like YO, delinquency, or expungements, we should think about what the purpose of the delinquency and YO proceedings are, and then come up with an independent list of offenses that we could use in that context. Because, for example, there could be some serious offenses that may not be suitable for a YO designation that are not listed offenses. So, for example, human trafficking is a listed offense, but prostitution-related slave trafficking is not a listed offense. Similarly, arson causing death is a listed offense. However, burning down someone's home where there's no death resulting is not a listed offense. So the question is, do we need to do a better inventory of offenses for this purpose instead of relying on the Big 12 enlisted offenses? However, what the last half of solution number 5 is designed to flag is, even if we engage in that exercise, the department still wants to use the existing standards for transferring cases between the criminal and family division. We just might need to tweak some of that language to make it make sense grammatically and so forth. But those existing standards are still applicable, and they're still good standards that we should be looking at. I did catch the comment about DCF suggesting maybe we rely more heavily on risk assessments for determining when, for example, YO status might be appropriate or family court jurisdiction in general might be appropriate. The state's attorneys agree that risk assessments are an important factor, but there's also other factors that might be important. And I tried to flag some of those in solution 2A, such as input of the victims, the nature of the charges, the alleged circumstances in which they occurred, and the impacts of a confidential designation on victim and public safety. So risk assessments are important and they're valuable. They shouldn't be solely dispositive, would be the state's attorney's position.
Senator White.
So I get really nervous when we start making a list of crimes that are and aren't eligible, just because the circumstances can vary so much from case to case. If you had the example that Evan used about the burning down somebody's house, some kid might be perfectly amenable to treatment and do very well, even if he burned somebody's house down, because and another kid may not. So I get very nervous if we start making lists of things that are not eligible. I even get nervous about the Big 12 and saying that they're not eligible if they're there. So I just needed to express that it makes me nervous whenever we just look at a list instead of the individual circumstance.
Yeah,
Did I just lose everybody?
no, I think
Oh.
I was trying to
Okay.
in agreement with you.
Nobody was moving, so I got nervous.
No, I think we should.
I want Alice to bob her head a little more so I know whether I've got the internet or not.
We already, I'm looking at Evan's list here.
I am too.
So, New York, the state's attorneys, and I agree with the state attorneys, are particularly concerned about the lack of secure placement. Evan?
Yes, I can. And a point of clarification that I might have forgotten to make earlier this afternoon, which is when we talk about, when I talk about a secure placement, I recognize that word can include both staff secure and facility secure placement. So the state's attorneys are not taking the position that we need a traditional jail setting in all of these situations, but there might be a need to have a limited number of in-state options for all demographics of individuals who might need one. So that's what I was getting at. And when it becomes particularly problematic is that interim period of time when perhaps we're seeking a placement at Sununu is just an example. There's been a couple of situations since I've joined the office in May where we were struggling to figure out where can we house this individual on a short-term basis, as short a term basis as possible, while we try and find a placement outside of Sununu. And unfortunately, on some occasions, that has meant an individual has to spend hours or overnight in a municipal police department, which is not ideal from the state's attorney's perspective. The Newberry facility is going to help out with that, but the Newberry facility might not be online for quite some time. And this is what I was trying to flag earlier when I said there's going to be some problems where we're not going to be able to develop an immediate solution. And this, I think, is going to be one of them because it has to do with physical space that may not be available immediately. In other words, there may not be beds that could be converted into an appropriate setting for juveniles, which is what we're talking about. So I think this is more a request on the part of the state's attorneys to be thinking about this issue, identifying where the gaps exist, and then trying to consider those gaps when planning for future bed space.
I think that could be incorporated into part of the report that we were talking about earlier from DCF, Eric.
Yeah. About
placement opportunities, particularly secure placement opportunities for 18, 19, and YO. At one point, I think Newport was going to be just for those under 25. But I don't know if that is still the case with all the changes in DOC. We had a bill that we passed was going to require them to be separate in housing, not necessarily in institutions. Try to separate out those under 25, the older offenders. I don't know whatever happened to that. You remember that, Eric?
I do. I thought it passed.
I think it did.
Yeah.
I don't know what, I mean. Is there anything else on Evan's list that we should put into the proposal at this time? We already covered the victims' compensation, etc. Did we go over explicitly state courts may order psychosexual evaluation?
No, not yet.
We should probably do that. Is anybody opposed to that?
What is the piece again?
Explicitly state that the courts may order psychosexual evaluations for individuals charged with sexual offenses, included in a minimum those listed in 28 VSA 204A and A little a.
Mhm.
Marshall, you have a problem with that?
I'm just looking at it closely. I mean, I think that what we just want to make clear is that what we're talking about here is disposition, that the judge can order psychosexual for purposes of setting up a disposition case plan, identifying, just that it's not, because I don't want it to be something, I don't want to read that as something that can happen, pre-adjudication or something that would be inappropriate.
Evan, did you mean it to be pre-adjudication or?
No. The idea is that it would be beneficial to make it clear to courts that they have the authority to order one of these when they're reviewing a case plan and trying to decide what the appropriate juvenile probation conditions should be. That's where, based on my experience prosecuting other types of sex offenses, that's, I think, where the real value of a psychosexual evaluation can come into play.
We have no objection to that.
Are those available? Are there enough people doing those evaluations that it actually could happen?
Yeah, I think so.
Frankly, in almost any, one of the problems with mushing together youthful offender and raise the age is that, so just to give an example, in a raise the age case, a case that's a traditional delinquency, there would almost never be any reason to get a psychosexual before you reached disposition. The exact opposite is true in a YO case, because in a YO case, as a juvenile, you're unlikely to be able to persuade a court that you should get youthful offender status without first having an expert who's going to tell the court about your risk and your needs, which really amounts to a psychosexual. So for the most part, in youthful offender cases, there's already been a psychosexual, but it's a psychosexual done by defense counsel, hiring an expert that was chosen by defense counsel. And so the court might want its own evaluation, or in a delinquency case, there may have been no psychosexual because you don't necessarily need one in a delinquency case prior to adjudication, at which point it's very appropriate to have one at disposition. And there certainly are providers that do them. I mean, it's a limited number, but they don't seem to be tapped out. I mean, we're getting evaluations done and returned pretty quickly from our providers. So it seems to be going fine.
Right. It is now 2:55. I don't want to hold this much longer. But I think we got plenty of work ahead of us. And I'm wondering if, Mike, you could have Peggy, or you could send out a doodle poll for the week of December 6th or maybe 13th, give people enough time and Eric enough time? Or should it be the week of the 6th?
I can do the week of the 6th, but the following week I'll be out of town.
Right. So if you could send out a doodle poll, Mike, or have Peggy do it. I don't know who does what for the week of the 6th, see what people are available. Because other than, I think the 9th is our all Senate meeting. So other than that, I'm free all week.
Senator Sears,
Yep,
can I just give a little update on something before we leave?
sure.
So I don't know if any of you remember when I reported out the burn pit bill a couple years ago.
Certainly do.
Well, one of the people that I quoted in there who was very instrumental in helping us was a young man who came and sat down in the witness chair and said, "My name is Wesley Black, and you're looking at a dead man." He was in his 30s, and he died yesterday.
Oh,
Yeah.
I do remember all of that.
Yeah.
It now become more of a national issue.
Well, it's still an issue in Vermont, and we're still working on getting people to sign up for it. It's,
That was good work you did on that, Jeanette.
but he and June Heston were really just superstars.
She came, you remember, she came within a handful of votes of
Yeah.
beating Chris Pearson. She
Mhm.
ran a great campaign.
Just to not leave that, but to go back to the week of the 6th, the 8th is the all Senate briefing, which
Did I
is,
say it was the 9th?
yeah,
Yeah.
Mhm.
so it's the 8th.
Thank you, because I have it written down as the 8th. I mean, as the 9th.
That's the pension committee, and you're welcome to come to it.
God, no.
Does anybody else remember? Is it the 8th? If Dick has it written down as the 9th, I think it's, I have
It's
written
the 8th.
the 8th. Okay.
I've been making mistakes.
I'm pretty sure it's the 8th because we have pension on the 9th.
Okay, I have it written down as the 8th.
And that week, are you restricted to Monday and Friday?
Yeah, I'm in my last week of classes that week. You're talking, Dick, about the week of the 6th?
6th, because you're not going to be available the following week.
Yeah, so I'll have my last classes Tuesday, Wednesday, Thursday of that week. Or yes, because they extended out till Friday, so I'm still limited to Monday, Friday that week.
Okay. Well. Eric, would you have this stuff done by November 30th? No, it wouldn't matter. Doesn't matter.
You mean to meet on the 30th?
No, to meet on December 3rd. If we put that in as one of the, so the doodle poll would be the 3rd of December, the 6th, or the 10th.
Yeah, I think it's, unless I'm missing something, I mean, based on our discussion this morning, I think it's pretty manageable. I'm not seeing,
Yeah.
lengthy
Well,
drafting that
yeah.
has to be done from scratch. It's more like plugging some things in here and there.
Yeah.
And it sounds like there may be a meeting of the stakeholders group tomorrow, so maybe they'll have a few more things to add to it. But I think and as you said, Senator Sears, it's a draft to get us started. So
Yep. And then
I
we
think
could get.
I think it's fine.
So Mike, if the doodle poll was for either the 3rd of, Friday the 3rd, Monday the 6th or Friday the 10th of December.
Would we not want to just decide here? Aren't we all here except for Joe?
Well, that's the problem.
Oh, okay.
He's probably the person who has the most conflicts.
Yeah.
Yeah.
Yeah, I can't do the 3rd.
I can't do the afternoon. Well, 2:00. I have to be at the Ludlow Electric Department meeting.
Oh. I didn't know there
Sounds
was a
like a hot
Ludlow
one.
Electric Department.
There's power in the state.
Oh.
Mhm.
Yeah,
So you have your own utility, just like, what is the name of that company?
Stowe.
Oh, we have Burlington Electric.
Yeah, but you also have a company there in Chittenden County that wants their own electric utility.
Oh, yeah.
Oh,
Yeah,
Global
yeah.
Industries.
Global, whatever. it
Yeah.
is.
Global Foundry.
Global Foundry.
Global Foundry.
Right.
Yeah.
All right. I think we're at a point where we could adjourn the meeting and go off of our live coverage and then discuss Yankee fans.
Before that, could I mention one last thing? Senator Sears?
Absolutely, Eric.
I had followed up with Michael Grady during the lunch break on the question of executive session. I know you talked about that earlier.
Yeah.
And he said essentially it's governed by the Senate rules, and that it's going to be John Bloomer who makes that call.
And he was, and Bloomer was the one that we talked to when we thought we might have an executive session. And he didn't tell us we couldn't, but he dissuaded us. I mean, it's pretty complicated, and you have to have a really, really compelling reason for doing it. And if you're talking about cases,
got
you
it.
could talk about cases by redacting names and identifying information and stuff. So it probably would not be a compelling case.
Okay, well, we have an actual problem here.
Huh?
Somehow I'm the host of this meeting and I don't know how to end it. And I have to make Mike
Just leave the meeting.
Just leave.
well, I have to make Mike, in order to end the YouTube, I have to make Mike the host, and I don't know how to make Mike the host. Somehow I'm the host. I don't know how.
Senator Sear,
Yeah,
Senator Sear, this is Mike. If you click on my name,
yeah.
it should give you the ability to make.
Okay, I'll see y'all soon.
Bye.
Hey, bye.
I'm gonna try to, oh, did I do it, Mike? Remove host, I just removed the co-host provision. Are you the host now, Mike?
No, I'm not.
It's not.
If you leave, it's on YouTube. Then you
I'm
can
now
leave.
pressing on your name. I got nothing.
This way.
I think we'll all leave and then
See what happens.
I'm just gonna press end and see what